Hello, and welcome to The Sage. I'm Paul Carlitz, CEO of Sagient in Los Angeles. I'm joined today by Andrew Marin, Esquire, to have a brief discussion on the basics of estate planning. We'll start with Andrew. Tell us who you are and how you got here.
I'm pleased to be here, Paul. This is very exciting. My name is Andrew Marin. I'm a California estate planning attorney and director of advanced planning here at Sagient.
Certainly seems like there's a lot of moving parts and people, families, situations change consistently. I know I'm not the same person. We're not in that I was 30 years ago. Family has changed. Children have grown up, all of that. How often should people be reviewing all of these documents and concepts and opportunities?
Yeah. So I would say that at the very least, when you have a triggering event, and a life triggering event would be a marriage, a divorce, a death of a primary party, something like that, where you're going to go in and know that you have to make some substantive change. Also, you're going to want to update things if you have a successor trustee, for example, somebody that's not actively doing anything today, but upon some future happening will be in charge. You might want to update your trust if that person moves away from where you are, or if they have some sort of other personal event happen that would no longer qualify them to be in that place. So I would say that, if things aren't changing and there hasn't been any updates in the tax law, that don't set it and forget it, but you don't need to be regularly reviewing it. Certainly upon some triggering event, pull the documents out, make sure everything still does what you want it to do.
Okay, great. And that's right. The set it and forget it was kind of what I was focused on. It's not a put it in the drawer, dust it off at the time of need, because you might not change, but the world around you might change.
Oh, it could be disastrous, because it could be that you haven't checked it in decades and everybody that you've named to take over or inherit is deceased. Mm-hmm. They're gone, or they're unable to, for whatever reason it may be.
Yeah. Well, we see a lot of times, when we're helping people with their plans, they've been divorced and didn't change their ex-spouse as a beneficiary of their 401k, right? Or whatever it might be. And it's just, or an old life insurance contract that they had that they bought many, many years ago. They didn't change the beneficiary. They're remarried. They wouldn't want it to go to their ex-spouse, but that's who it's going to, because they're just going to follow whoever's written there.
Yeah. Don't do that.
So we mentioned earlier the idea of these are not documents and concepts to just set and forget. So it makes me think of the other term you used, triggering events, which I think is a great one, because I think that's what gets everybody thinking, is oftentimes that triggering event is having a child, right? That's oh boy, we had a child. It's time to adult, right, and get this stuff done. And now people set up their wills, trusts, guardians, all the things we've kind of hit on earlier. I imagine there might be two ways of setting that up. One is where they actually name the child in the will as the beneficiary or whatever it might be. But also there's opportunities where they just say children born of the marriage. If it's the latter, well, either, how important is it when you have child 2 or 3 to go in and update the documents to specifically name them, or is it okay to just leave it kind of open-ended? Mm-hmm.
It's a great question, and it really depends on the original will it was constructed. If it was constructed by just naming the first child and that was it, with the advent of additional children, you're going to have to change what the will states. If you have a will, rather, that says that everything is going to go to the descendants, for example, and descendant is defined as either somebody that they had personally or an adoption that they had, then that's another way to get around it without doing it the other way.
Okay. And that would suffice to leave it as any other descendants. That's
Absolutely.
Good enough.
Absolutely.
Okay. So wills, trusts, all of these documents and plans that we've talked about, Are they vulnerable to lawsuits?
It's a great question, and the answer is yes. And the answer is yes, depending on assets that are controlled by that individual. So if you have a revocable trust or a will that's set up and you are sued, somebody can come after those assets that are in there. Now, I'll give you an example of something like a rental property. You have your primary house, then you buy a house that you want to rent. It would be important to remove that from yourself, because if somebody were to trip and fall inside your rental house and sue you, they can come after everything associated with you. So chances are you'll have what's called an insurance policy on top of that to protect from your home, an umbrella policy, they call it. The problem is, if there were damage above and beyond the umbrella coverage, let's say you have $1 million coverage, the damage was $2 million, the person that was hurt can come after you for that other $1 million. So we want to make sure that assets are set up in such a way that they are protected, that they're defended, and that they're not coordinated overall.
Okay, that makes sense. So we've hit on it in a good way, I'd say ad nauseum, that these topics are not set it and forget it. But that leads to the other question. Do you do it all at once? And do you wait for a certain amount of stuff to attack and do it all at once? Or is there an order? Or how would you address that?
What clients want to do is make sure that they do things in a certain order. And for a young person, it can be just having a power of attorney or a healthcare document in place. But for anybody else, we want to make sure that they have a trust set up to have privacy for whatever they're transferring, that their goals are set up and accomplished that way. And then they have somebody to oversee all of those things in the event that they're incapacitated. Now, if we have something like an estate tax problem, meaning that somebody's individual net worth is either taxable now or might be taxable in the future, there are different ways to move those funds out of one's estate, like transferring them into an irrevocable trust, for example. Now, in order to do that, you're going to have to give up some or all of the control on the asset, but there's still a way for you to get some, let's say, distribution from that, and then all of the growth in that outside trust will be completely away from your independent net worth.
Okay. What is an insurance trust?
So an insurance trust is a trust set up to own an insurance policy. Similarly, you have a grantor, the person that's establishing the trust. You have a trustee, the person that's going to manage the trust assets. Then you have a beneficiary, is the person that's going to benefit from whatever's in there. So an insurance trust is most often set up to own the insurance policy. Now, if it's what's known as a term policy, it's just going to be a death benefit, and it usually is not paid out until the death of the person that's insured. If it is a non-term policy, we'll call them a whole life policy, it might be that there's cash growth in the insurance policy that can be accessed during life, and the death benefit can still be around during passing.
Okay. Another topic and another trust question. What's a credit shelter trust?
A credit shelter trust is something that couples will set up to take advantage oftentimes of the estate tax exemption. So today it's $13.6 million. Back in 2000, it was $600,000. Obama upped it to $5 million, and then Trump upped it to $11 million. Now it's 13.6. But what happens with a credit shelter trust is that upon the passing of one spouse, they will use the funds to fill up what's called a credit shelter trust or a bypass trust that becomes irrevocable with the full amount of money that they can, usually determined by what the freebie would be, which is $13.6 million this year. So by transferring all of that money into the irrevocable trust, the surviving spouse can still get access to some of the funds. And then anything left over that is above and beyond that 13.6 will go into what's called a marital trust, still have full access to it. So a credit shelter trust is set up to be able to take advantage of whatever the estate exemption is for that year, allow access to it from the surviving spouse, but make sure that that appreciation and growth is separate entirely from the family that's remaining.
And you're protecting that because it's kind of use it or lose it?
Exactly right. And I'm glad you brought up that point. If we have somebody pass away yesterday, they're entitled to transfer $13.6 million at their death without paying any taxes.
And we said earlier that estate taxes aren't due until the second death, meaning the second spouse dies. So does that mean the 13.6, if done properly, is really 27.2, which is 13.6 per? Or is it use it or lose it there? I know there's the laws changed in the last handful of years, and there's something called portability, which does that make a credit shelter trust moot?
No.
Or is it still important because you're still trying to make sure if something happens to be, there's no estate tax due until my spouse dies, but I want to make sure at her death, hopefully many, many years down the line, she's getting the benefit of my 13.6 today, even if it's 20, 30 years down the line.
So the credit shelter trust was really a popular estate planning tool when the exemption was much lower. In 2001 under Bush, it was about 500,000. Then it went up under Obama to about 5 million, and now it's over 11 million with Trump. Portability came around about 10 years ago, which says that you don't have to use it right away or lose it, but you can port over whatever available exemption was to the surviving spouse. So to your point, somebody can certainly do the paperwork and use it to port over to the individual that's surviving for the future. One of the reasons that you might not want to do that is because you can transfer today $13.6 million of assets into an irrevocable trust. And because it's irrevocable, all of the growth and appreciation in that trust for those assets will be outside of the estate tax. Okay. So it's very important for those that have that problem to ensure that they're utilizing it while it's around.
Is there who decides how assets are ultimately distributed?
It's a great question. So I'm going to say it depends on whether or not you have an estate planning vehicle, because we'll start with the easier one first. If you were to pass away with no trust, no beneficiary designations, everything is owned by yourself, well, your loved ones are going to have to open a probate petition with the court and then petition the court to look at their intestacy laws, which determines who gets what when. So most often, if a spouse passes away, the state of California, for example, will say everything goes to the wife or the husband. And if both of them pass away, everything goes to the kids, so on and so forth.
I imagine, are there age restrictions on distributions?
Absolute great question. So there is not an age distribution or an age restriction for distributions. However, a minor is going to receive those funds oftentimes through their appointed guardian, because a child is going to have a guardian, whether that's nominated in a will by a parent or through the court system itself.
Okay. How can an estate, what does it mean when someone says they've contested an estate?
It's a bad place to be and a great question to ask.
There's a dichotomy for the day.
Right. So to explain the contest, so you can imagine, what is a contest? It's a challenge between people. So a contest clause, let's start with that, is something that many individuals, certainly we draft in almost all of our trusts, is going to be something that says a beneficiary that challenges the wishes of the grantor, the person that set up the trust, forfeits what they're going to get. So I'll give you a real life example. Parents have a trust, one parent passes, now the second parent passes. Everything is going to their 3 kids. One of the children claims that he or she should have gotten more than the other 2 siblings. To avoid that fight from happening, the trust will say there's a no contest clause, which means that you cannot fight among each other. If you do, you will be removed from a beneficiary. So it keeps the peace after somebody is gone. Without a no contest clause, it's free game for people that want to scream and shout.
So this sounds like you're taking your kids right back to childhood, meaning if you take Billy's toy away, you're going to your room versus sharing it. So,
I'll mention a quick aside. My estate planning professor in law school shared something that I thought was a joke, which is first grief, then greed.
Yep.
Very appropriate.
Yeah.
With these planning situations.
That makes sense. We've hit around it. What if the worst happens? An entire family is involved in a fatal accident. What happens to the estate? I know we hit earlier on somebody survives 10 seconds or 10 minutes or 10 days, but what if an entire family is, for lack of a better term, wiped out?
Yeah. Yeah. In this horrific event, there is something in the trust, certainly that's there, and it's called a family disaster clause. And this would be in the event that the plane goes down, the car crashes, and everybody is at the same time, they're gone. Most times we see that individuals will choose extended family members for this. They'll choose friends, or they'll choose a charity, or a combination of the few there. So it's certainly in many trusts planned for. Of course, heaven forbid it never happens.
So let's get practical, right? Let estate planning or estate tax planning, I guess, in a practical world. Is there one form, right? And these days everything's online. Has it gotten to a point where there's one form that just takes care of all of this?
Maybe someday, but not today.
Not now.
Not today.
Right.
Yeah, unfortunately.
Wishful thinking, maybe?
Yeah.
Is that where we're at? Okay.
Let's make it happen. But I'll say, just to add to that for a moment, that it really is case specific for everybody that walks in your door. Some people are going to have a giant estate, but don't want to do any estate tax planning because they know that they're going to gift everything to charity afterwards. So for those instances, we don't really need to play defense because it's going to be a charitable donation. For others that may have, an example, a special needs child, well, we have to do much more to ensure that the funds are going to be delivered in the right way.
Are there many differences from state to state, or are all 50 pretty much in lockstep, or is it really a smorgasbord?
So it really is the latter that you mentioned. And the largest thing that I'll mention now is really the difference between community and separate property states. Here in California, we have a community property state, which means that the husband and wife both have a 100% interest in that community property. And upon the passing of one, you get what's called a step up in basis, which is going to complicate this a little bit, but let me explain. Your basis is what you purchase something for. Now, the growth on that is going to be what you're charged capital gains taxes for, or losses, depending on if the asset appreciated or went down. So when you get a step up in basis, the government basically says that any of your purchase prices, we're going to pretend that they increase to the value of the date of death. So it effectively wipes away all of your capital gains taxes. So in a state like California, you have 100% step up upon the passing of the first spouse. In a non-community property state, known as a separate property state, upon the passing of one spouse, you only get 50% of the step up. So I would say that is a widely utilized difference between community and separate property states across the country.
How does that differ from, you mentioned it earlier, kind of that unlimited marital deduction between spouses?
So what we see happen quite often is that upon the passing of the first spouse, you have the unlimited marital deduction, which applies to everybody, which means that there's no estate tax due. However, for the community property side, it affects not estate taxes, but capital gains taxes.
There we go.
So we have, in a community property state, all of the capital gains will be erased upon the passing of the first spouse as a step up. In a separate property state, only half of those will be. So again, there's no estate taxes that are going to be owed. There's no taxes at all that will be owed upon the first spouse. However, if you were to sell some of those assets, you would not have a full step up in a separate property state as you would in a community property state upon the passing of the first spouse.
Got it. And what about property or businesses in another state? How is that I don't know if calculated is the right word, or accounted for in estate planning?
Yeah. So it's a terrific question. And it really depends on what state you're in, what they offer as far as the benefits and protections and liabilities within that state. But let's use California and Nevada, for example, or Arizona, a neighboring state. What we're going to want to do is have our estate planning documents still in the state that we reside. Let's assume we live here in California. And we're going to want to account for that piece of property. Now, in a previous example, we talked about diversifying some assets so that if somebody sues you, they can't come after everything in the same name. So if everything is titled in Andrew Marin and I have a real estate property and somebody breaks their back, they can come after everything that Andrew Marin has. In that exact same example, if that rental property instead was in an LLC or a limited liability company, an entity, a business, then that same person that broke their back could only come after the assets in that trust and, of course, any insurance that's available there.
Makes sense.
So I would just conclude with it's important to plan in those separate states using the laws of those states and any beneficial treatments that you can.
Makes sense. We hit a little bit on gifting. We talked about the marital deduction, unlimited credit. Is there you mentioned a couple times federal estate tax, and I think you alluded to earlier that some states may have their own estate tax and some may not.
Yep.
Can you maybe walk us through what a state estate tax is and whether, and maybe some states that do and don't have it?
Absolutely. So let me just start setting the stage with the federal exemption in tax and what we're doing. So right now we have passed by the Tax Cuts and Jobs Act in 2017 an $11 million exemption indexed for inflation, which is today 13.6. So that means that you can give to anybody else $13.6 million without any tax. Anything above that is subject to at least 40% taxation. Let's say some states don't have any state death tax. So your federal death tax is anything above 13.
Ooh, that's juicy. You went from estate tax to death tax. There you go. I like it.
Inner workings.
I like it.
Slip of the tongue, but we'll keep going. So the freebie from the government federally is 13.6. Some states like California have no state death tax or estate tax, meaning that you can die in California with $1 trillion and California is not going to tax you anything on the death tax. Federal government will still get you.
I know New York has something called a cliff tax provision. Pretty sure that doesn't have to do with the amount of Cliff bars you own, but maybe you can share with us what that cliff tax provision is.
It's exactly right. So this is a similar type thing that we were talking about with the state taxes and what the cliff tax provision in New York says, and I'll round up the numbers. If you pass away with $7 million in your name, you are free of tax. The state of New York will just let that pass. If you are 5% greater than $7 million for the total of your estate, so let's call it $7,500,000, then the entire estate is taxed.
So retro.
It is retro.
It's retroactive to the full
full amount there. It's not the difference between the $7 million and the excess. It's the entire caboodle.
And traditional estate tax is federal, is not retroactive. It's on the overage,
That's
correct?
A great point. Exactly right. So anything up to that amount will pass tax-free, and then anything above that amount will be taxed. One additional point, too, is any planning that one would take advantage of now and plan for, even though in the future the exemption will be lowered, they can't claw back any of those valid gifts made in those previous years.
Right. So if you make the move now, proactively, that plan gets locked in to your benefit, not to your detriment.
I would say that's the most encouraging thing to get across to people.
Okay.
Is do the planning now. It can't be taken back then. And much of it, again, with revocable trust can be changed.
Okay. Interesting. With this conversation around some states have a state tax, some don't. We see a lot of people moving cities and states based on income tax. We've seen a lot recently in the media about athletes signing these 7-digit, 10-digit contracts, and then I don't know if they're crying about it, but you're hearing, well, it's not as much as you think because we get taxed in every state we play in if it's a sport. So what happens to an estate if I do all the work here while I'm in California and then I move to another state?
Terrific question.
Or my beneficiaries,
yeah.
Right? I die and they've already moved to another estate, right? Our kids grow up, they don't necessarily stay next to you, and they're the beneficiaries, or if I set it up and I move. I guess that's maybe 2.5 questions in there.
Well, I'll start with the football piece, which is every state they play in, they're taxed in that state. So that's certainly true. And then I'll take the beneficiary piece first. the beneficiaries of the trust can be anywhere in the world that they want to be. They're still going to have access to the trust. It's not state specific by any means.
Okay.
Now, if mom and dad are the grantor, settlor, trustor, this is all synonymous for the same thing. If mom and dad are in California and they're thinking about moving to Texas, for example, which we're seeing is kind of a common move to be made, then what happens is you can take the estate planning document that was drafted here in California, and you can do oftentimes what's called a change of governing law in the other state. So in California, a trust will say, governed by California law, blah, blah, blah. You can change that provision of the trust to accommodate the new law in Texas, for example. Now, that doesn't always work with the documents, and it may be that you need to redraft them in that state because they're no longer effective.
So thank you, Andrew. I thought this was a terrific conversation. We clearly covered a lot of ground. And thank you for watching The Sage. Again, I'm Paul Carlitz, the CEO of Sagient, and this is Andrew Marin, Esquire, also of Sagient.